Did Paul ever give you all my MJI information password right?
I'm sure she did. Let me look into that. Come on. I look like a New Orleans. Yeah. What were those letters that you gave me, John? Oh,
Yeah. Institute.
All right, I'm looking for your password right now. Okay.
Search for a word. You know how you can search it.
MJI, I will print you off right now. Okay, is it MDJA or the MJI? Okay, just saw that. BA.Oakley is your username. All caps. Password Cheyenne34. Capital CHEYENNE.
Oh, can you hit the other button? You can't make it show your password? Sometimes you don't even like that. Oh my gosh.
I don't know if they want, I don't know what it's called, you know what I mean? Yeah. The first letter might be that, all that, certainly, I don't know that. I don't know what.
So yours is, so once you have the first letter down.
Oh, I got it.
Yeah, yeah. So, yeah, this is where I'm at right now. So. And then I'll let go. Yeah.
Of course, they wait till the day, so they do stuff like that, you know. But I got mine.
Yeah, and type in all that. So,
The problem, and open it, figure out what, why. Because
When my mom was before,
Mhm.
they sent me a revised statement of what I owe. Because they said I owed money after she left. It said zero,
Oh, oh, good.
because I really thought I would have been. When I did the insurance, I would have been nuts, but.
Yeah. So at first they were saying you still owed?
Yeah, I paid the 30 days after. Didn't give them a 30-day notice. But I was going to give a 30-day notice.
Right.
okay, I did copy and paste the verification code and it's set. How is that your problem?
Do you want me to try to mess around with it? Okay.
And every time we have a problem, Paul has to call.
Okay.
So I'm gonna send you what I'm trying to add.
Okay.
Good morning, Heather.
Good morning, Sandy. Uh-huh. Hi, Mr. Betts.
Good morning.
Good morning. How many cases do you have this morning with us?
Just one.
Just one, the United Lab versus Nationwide?
Correct. Yes.
All right. Nobody else is here on the other side. So I'm going to put you back in the waiting room and I wanted to say hello.
Okay. Thank you. Bye.
Yeah.
Anybody else?
Recording in progress.
Hi, Alice.
Good morning.
Good morning. What case are you on this morning?
I'm here on United Lab v. Nationwide, case number 202747, and I represent Nationwide.
Okay, instead of Mr. Lewicki?
Correct.
We're here in his place. Okay, thank you. That one should be handling pretty soon because the other side is here. So it'll be just a little.
Okay, great.
Thank you.
Thank you.
Heather, I don't know what I just did, but I just lost it.
They're both still on the screen.
Yeah, but I'm not watching. I don't have anything on my desktop now.
Oh, I'll be right in there.
Huh. I think I kicked myself out of my own meeting. I just have to put the password on again. The meeting ID.
You shouldn't have to because you're already in the meeting.
It showed me the box for live streaming. I just thought I was just closing that box. You know, I had the box.
I can still see and hear you.
Well, that's weird. Thanks. What the hell was it? See, I clicked on that X.
They got it.
All right.
So that's still.
I don't know. All right. Good morning, you two.
Good morning.
Yeah, there you go.
How about appearances on United Lab versus Nationwide?
John Betts for Plaintiff United Lab RX.
Good morning, Your Honor. Alice Fabashevsky on behalf of defendant Nationwide.
Thank you. Where are we at? I think we
Your
just
Honor,
adjourned for discovery
plaintiff
last
counsel
time.
and I had an opportunity to talk yesterday, and I did inform him that the claimant has his own case in Oakland County Circuit Court. Just last Wednesday, we had a hearing on a motion to dismiss because the plaintiff has not participated in discovery whatsoever. Still haven't gotten his deposition, initial disclosures, answers to discovery. But the judge at that
Right.
time gave the plaintiff 30 more days to comply. But at the end of that 30-day period, she indicated we could submit a final order for entry. There's no need for another motion hearing. So if
Okay.
we could put this over until the expiration of that 30-day period, that
Okay.
would be
Mr.
very
Betts?
helpful.
Any objection, Mr. Betts?
No, Your Honor.
All right, so we're just going to adjourn the pretrial for 30 days. And civil will just send out a notice.
Wonderful.
Thank you.
Thank you, Judge.
All right,
have a good day.
What do you got? Oh. I will hit that button again. All right, just pile up.
Sandy, are you listening?
Yes, ma'am.
Somehow you became host.
That's funny.
Yeah, can you make me host, please?
I can do that as soon as I. When I click on more, it doesn't say anything about making anybody host. It just says rename and add profile picture.
But next to me, click next to my name.
Okay.
For the more
Got
and then
it.
make me host.
Yeah.
Yeah.
I haven't done that in so long.
Thank you.
You're welcome. Heather, are you there yet?
So Daryl is at 8:30. Matthew is at 8:30 also. Who's John Mueller?
I wonder if Daryl is Daryl Garrett. He's the other side of the case with Mr. Mueller.
Oh, yep, I see Mr. Mueller. Yep, that's what I'm going to guess
Let's
too.
bring him in.
All right.
Good morning, Mr. Mueller.
Good morning, Judge. How are you?
Better than I deserve, counsel.
Okay.
We're trying to get Daryl's iPhone connected to make sure it's the right Daryl.
Okay.
I'll leave it there because I keep walking by the one side. I asked you. She said, okay.
Thanks. Thanks, Jake, Jamie. Looks like he's having trouble connecting, Counselor.
All right.
I chatted him, Judge.
Thank you. Hopefully he reads it. Mr. Mueller, today's the date and time set for a show cause, correct?
That's correct.
Thank you. Well, I've got his video, but I still don't have audio. Daryl, are you connected?
I chatted him again. Oh, let's see. Okay, so
Mr. Mueller, when was the creditor's exam scheduled that Mr. Garrett did not show up for?
I show it May 17th at the court.
Thank you.
There was a proof of service sent in. There was personal service.
Thank you. Daryl's iPhone, are you connected?
Yes.
There we go. Is your last name Garrett?
Yes.
Thank you. Counsel, your appearance for community financial credit.
John Mueller appearing on behalf of the plaintiff.
Thank you. All right, Mr. Garrett, today's a show cause hearing because you failed to show up for a creditor's exam back in May. Do you remember getting a notice for that one, or did you miss the notice?
Missed the notice.
All right, so counsel, we can reschedule, or I can put you two in a breakout room and see if you can accomplish something today.
If we reschedule, well, obviously I shouldn't say obviously. I'm assuming he doesn't have financial records with him today.
Probably not. Do you have immediate access to your financial records, Mr. Garrett?
No.
All right. Do you have an email address that Mr. Mueller could send you a subpoena? So you know what records you're going to have for this next court date?
You can mail it to me.
Well, I'd rather do an email because mail didn't work last time.
My name, Daryl.Garrett at live.com.
Daryl.Garrett at live.com.
Yes.
And Sandy, do you have another date and time for a creditor's exam?
Yes, we can do 10/18 or 11/22.
Any preference, gentlemen?
10/18 would be my preference.
All right, what time on the
9
18th?
a.m.
9 a.m. All right, and Sandy, is there a Zoom ID number that Mr. Garrett has to have?
Yes, there is. Whenever he's ready, I can either chat it to him or tell him now.
Mr. Garrett, you know how to use the chat function on Zoom?
Not really, no.
All
I'm
right.
new to the Zoom.
Grab something to write with then. We're going to give you a Zoom ID number that you're going to need on October 18th.
Okay.
Sandy, you're also going to mail a notice, correct?
Yes, we will.
Okay.
Okay, that Zoom ID number is 297-224-4732.
Okay.
You got that okay, Mr. Garrett?
Yes.
All right, and in the meantime, Mr. Mueller is going to send you an email telling you what information you should have available that day. Correct, Mr. Mueller?
That's correct.
All right, anything else, gentlemen?
We had a different Zoom number for today, but we're gonna use that one that,
Yeah, because right. Today's Zoom, you're in the courtroom with me. That day, you're not in the courtroom for the creditor's exam.
okay, perfect. Thank you, Judge.
Have a good day, gentlemen.
Thank you.
You too. Thank you.
Judge Matthew Clark is here with, it's
Yep.
the other party. Okay.
Crown Asset. Yep. Thank you.
Your Honor,
Yes, sir.
may I speak with Mr. Clark before you call the case, please? This is David Canine for
Sure.
Crown Asset. Thank you.
Sure. As soon as we get him connected. Mr. Clark, are you there?
Hello. Good morning.
Mr. Clark. Mr. Clark, plaintiff's attorney has asked for a breakout session with you. We're going to put you in a private conversation room.
All right.
All right.
Thank you.
Thank you.
We'll talk to you gentlemen soon.
Dawn Davis, hers is Midland Credit, but the other party's not here.
Yep.
And Diversified is the other
Austin.
one. Okay, yep.
Yep.
Great. Okay.
Yep. Thank you.
Yep, now we have Stephanie Petway.
That might be one of our attorneys.
All right, I'll let her in because I'm not seeing her.
Yeah, let's bring her in and see what firm she's from.
Miss
Good morning,
Petway?
Ms. Petway.
Hi, good morning.
Sorry.
Which case are you on?
I have two scheduled for 8:45. I represent Midland. The defendant on the first one is Dawn Davis, and the defendant on the other one is Ellis Shropshire.
All right, we've got Miss Davis, so we'll bring her in.
Okay.
Good morning, Miss Davis.
Good morning.
Counsel, your appearance for Midland, please.
Thank you. Good morning, Your Honor. For the record, Stephanie Petway, P64543, appearing on behalf of the plaintiff.
Thank you. And we scheduled a pretrial for today. Miss Davis, a pretrial is an opportunity for me to get some information about a file so that we can put it on the calendar and hopefully move it towards a resolution. Do you understand that?
Yes.
Counsel, where are we at? Do you need discovery?
Your Honor, actually, Ms. Davis filed a written response indicating that she's suffering some financial hardship. We did send some documents out to her. Ms. Davis, did you receive anything regarding that hardship?
I have not. I left on a vacation on the 31st, so I'm not sure if it got there in between there or now. I'm on my way home now, so I have no idea.
Okay. Your Honor, if you have no objection, could you put us into a breakout room so I can explain in further detail what the hardship program is?
Absolutely. All right, Ms. Davis, we're going to throw you into a meeting room so it could just be a private conversation with you and Ms. Petway.
Okay.
Doing it now, Judge.
Good luck.
Thank you.
Should I bring in Preston Nate to see what he's on?
I found him. He's on JP Morgan at 8:45.
Oh, okay. Thank you.
And no defendant yet.
number you have dialed is not in service. Please check.
Give me a second, gentlemen.
No problem.
Okay.
Enter the first 3 or 4 letters of the person's first or last name. For who, press 7. Extension 2, 2, 3. To call this person, press 1. To change this person, press 2. Please wait a moment. Mailbox 2, 2, 3. Please leave a message at the tone. To end recording, hang up for 1 for more features. Calling the operator. Please wait a moment. Oh, they did. The same thing is whenever some famous, foreign cellist or slouches. Yeah, they sing their song, Remember This.
Not impressed with that law firm's phone number. Heather, let me give you a number.
All right, ready?
248-352-4340.
Mm-hmm. For Mr.
Try to get the
Holzman.
operator. Yeah, try to get the operator to talk to you and find out where he's at on Diversified.
All righty.
All right, Mr. Canine and Mr. Clark, where are we at?
Mr. Clark has indicated, so the original creditor here was Old Navy. Mr. Clark thinks he only had one Old Navy account, which he was previously sued on, and it was reduced to judgment, and he was garnished at one point. I told him I have no record that this was paid prior or that we're talking about the same account. He'd like a little more discovery, maybe just a week or so, where I basically suggested to him that he pull the court file for the case that he was previously sued on. And there should be an account number, an original creditor, an account number in the complaint of that file.
Right.
So maybe just a very brief period of discovery, Your Honor, additionally. Thank you.
Okay. Mr. Clark, was that case through our court?
Yes, sir.
Okay. Sandy, could you do that right now?
I'm going to try and look it up right now. Yep.
Thank you.
Do you remember who the plaintiff was on that, Mr. Clark?
I haven't pulled it up.
Give me
I want to
any more information. Can you give me roughly what year that was?
I believe it was 17, 18, and reaching into 19.
Okay, that'll help. Your name's a little bit common. You know, Matthew Clark, we probably have more than one in the system, so that'll help us narrow it down maybe.
Yes, sir.
Your address been consistent for that time period?
Yes, sir.
Okay,
I did find one for 17, and I believe I can ask Marie to go pull it, but it's going to take a few minutes because it's over in the old building, or in the barn.
Okay. All right, then let's do this. Sandy, what's the next time we can get these fellows a pretrial date?
We have 9/21.
Time?
We can do 9:30.
All right. In the meantime, Mr. Clark, give me a phone number for you.
You ready?
Yep.
313-758-8588.
8588.
Yes, sir.
All right, Sandy, if you don't mind, if we're successful in locating that file, can you give Mr. Clark a phone call and he could just come in and look at that file and get whatever copies he needs out of it?
That is, yep. Or I can even email them the copies of the complaint.
Okay,
That'd be perfect.
okay. All right,
Thank you.
Mr. Clark, we'll reach out to you when we get off the docket then.
All right,
Can
thank
I
you.
have Mr. Clark chat me his email?
Mr.
Yep.
Clark, can you do that?
Is that Miss Heather?
That's all right. You can send it to Heather. That's fine.
Okay.
And Your Honor, you
All
said
right.
September 21st at 9:30 is our next date, correct?
Yes, sir.
Thank you.
Yep. Good luck, gentlemen. I would encourage you to share information between now and the 21st.
Yes,
Okay,
sir. Thank you.
we'll do. Thank you. Take care.
Have a good day, Counselor.
You too, Your Honor.
All right, back on the record with Midland Credit versus Davis. Ms. Davis, are you there?
Yes.
There you are. Good morning again. Counsel,
Morning.
where are we at, Ms. Petway?
Your Honor, thank you for that time. I was able to explain to Ms. Davis that my client does offer a hardship program, which I think she would benefit from. Unfortunately, we did mail it out, but she doesn't know yet if she's received it because as she indicated, she's been traveling. So I'll leave it to Your Honor's discretion whether we should just adjourn today's hearing to allow her time to get that packet, fill out the information and send it back, or whether Your Honor wants to enter a scheduling order, give us time for discovery, and that also would give us sufficient time to review the hardship.
Let's do this. Let's adjourn the pretrial
Okay.
to September 21 at 9:30. We'll do written discovery until then. That's just so you can do an exchange of information both ways, Ms. Davis.
Okay.
And Ms. Davis, when you get home, if you don't have that packet, I would suggest you reach out to the law firm.
Yes, she
And
gave
ask
me
them
her
to
phone number to
resend.
call her.
Okay, perfect. Anything else we can accomplish today, ladies?
No, I think that's it, Your Honor.
Nope.
Thank you.
I think we're good.
All right, good luck, Ms. Davis.
Thank you.
Take care, Ms. Davis.
Council, have a productive day.
Thank you.
Judge?
Your Honor, I don't know, did my other
Yeah.
defendant appear?
No, not yet.
Not yet.
Okay, thanks.
We'll leave you right there. I love the color of that wall behind you. I like bright
Your Honor,
colors.
this was originally our game room until everyone had to start working from home. So then it became my office. But it was fun
It
as
works.
a game room.
It works. All right, just hang out with us. Hopefully the other defendant will show up.
Okay,
What do you got,
thank you.
Heather?
Still no luck on Holzman. You get hung up on because they don't have room to leave a voicemail. And Mr. Matthew Clark, I think, came back because you removed him before he was able to chat his information.
Oh, I'm sorry.
Nope, that's fine. So I'm bringing him back in.
Yep, that's fine.
Okay, I have it now. Thank you, Mr. Clark. I'm going to remove you now. I don't know that he can hear me. Let me, thank you. I will remove you now.
So when you got a hold of a Holzman's office, you couldn't leave a voicemail.
No, I could not leave a voicemail.
Judge, I just tried another number at Holzman and their office is closed. They don't open till 9 a.m.
Okay.
Sandy, I just chatted you Mr. Clark's information.
Thank you.
Do you see Matthew Nichols' name on the board anywhere? I'm guessing he might be an attorney. Oh, okay, thanks. Hey, Heather.
Yes, Judge.
Capital One versus Kozak, which is one of our 930 cases.
Uh-huh.
Nick just brought me in a consent judgment that they submitted by email.
Okay, and Crystal Mountain is on the phone with me right now, so I will be a few minutes, okay?
Yep. Mr. Nichols, what are you here on?
Hi, good morning, Your Honor. How are you today?
Great.
Good. I'm here on Kirkridge Park Cooperative versus Ashley Kroll. Do you need a case number?
Nope, I've got the file. I don't have the defendant yet. What time was that
Okay.
scheduled?
I believe it was for 9 o'clock, and I am expecting the site manager from the cooperative, Miss Lett. So if you want to just pass on the matter and call us when the court's ready, I'll be waiting.
All right, I'll watch for your manager too. Thank you.
Okay, thank you, Your Honor.
Good morning, Ms. Jackson. Good morning, Ms. Jackson.
Hi, how are you?
Wonderful. I just wanted to let you know that we're waiting to see if the attorney's going to join us. And
Okay.
at 9:15, if the attorney hasn't joined us, then you're going to win. I'll
Thank you
set
so
aside your default
much.
judgment.
Thank you
So just
so
hang
much.
out with us there. I'm going to mute you for a minute, and we'll talk again hopefully soon.
Thank you.
You're welcome. Ms. Petway, I think we've got Mr. Shropshire coming in.
Okay.
Ellis's phone, are you connected?
Yes.
Are you Mr. Shropshire?
Yes.
Good morning, sir. Counsel, your appearance for Midland Credit.
Certainly. Good morning again, Your Honor. For the record, Stephanie Petway, P64543, appearing on behalf of the plaintiff.
Thank you. And this was an adjourned pretrial, correct, counsel?
Your Honor, actually, I don't know that it was adjourned. From my notes, it appears that the defendant filed a motion to set aside the default judgment. We never received a copy. We never received a copy or the notice of hearing, so we didn't appear. And because we didn't appear, or maybe based on the merits, I don't know, Your Honor granted the motion to set aside. So we got a copy of Your Honor's order. I think it was dated June the 23rd, which is the only way we knew what had occurred. And then the pretrial was set for today. I don't know if Your Honor required Mr. Shropshire, woo, that's hard to say. I don't know if Your Honor required him to file a written answer after you set aside the default judgment. We just, like I said, we just got notice of today's pretrial, and that's how we found out the judgment had been set aside.
Gotcha. I gotcha. I don't think I required an answer. Doesn't look like it.
Okay.
Why don't we do this? Why don't I put you and Mr. Shropshire in a breakout room, have some conversation, and then we'll get back online and we'll do something official.
Okay, sounds good. Thank you, Your Honor.
Mr. Shropshire, we're going to put you in a breakout room so you can talk privately with the counsel.
Okay.
I think Heather's tied up on the phone, so it might be a minute. Let's see if I can get you in a breakout room without losing you two. I cannot. So hang out, Mr. Shropshire. Ms. Pelway, hang out until we can get Heather back on with us.
Sure.
No problem.
Good morning, Mr. Beach.
Good morning, Your Honor.
Which case are you on, Mr. Beach?
I've got CACH versus Qual.
Thank you. And I do not see our defendant yet. What time was that one scheduled?
Scheduled for 9.
9 o'clock. Okay. All right. So hopefully he'll join us soon. Okay, yeah. So in June, we set aside default judgment and put a discovery period out. Okay. So let's see if he joins us.
Okay, thank you.
I think. No, I don't have a phone number for him, so I can't call him. All right, we'll just watch the clock, see what happens.
Okay, thanks, Judge.
Sandy, did Heather make you co-host?
No, she did not.
All right, we had it all set up, and then for some reason it shut down, and I think she forgot to do that. It says I'm co-host, so I should be able to do breakout.
Fred's looking into it, Judge.
Thanks. Good morning, Mr. Nate.
Good morning. How are you doing?
Excellent. I've been watching the breakout or the waiting room for Mr. Luciani. Had not seen him yet.
Okay, he may have an attorney. I know he was working with Jennifer Palin, who she may have gotten a appearance.
Oh, her name, yeah, her name is on the ROA.
Yeah,
I don't
okay.
see her yet either. You got a phone number for her? Maybe you can give her a call.
I can find one probably. Yeah.
I've got one if you're ready.
Yeah, if you've got one, go ahead.
313-405-7064.
Okay. Yeah, I can try to give her a call real quick. I know a lot of times she
Please.
has appearance counsel. So I'm not sure if there's another attorney on here appearing for her. But yeah, I'll give her a quick
So
call.
far, everybody I've got involved, I know who they are and what case they're on.
Okay, sounds good. Yeah, let me try to give her a
Oddly
quick
enough.
call, see if I can find some answers for us here.
Okay.
Put you on. Your Honor, so that number didn't get picked up. Let me look one more place. I might have a different number for her. If you want to give me another maybe a couple minutes, I'll see if I can get another number.
Sure. Go ahead.
Okay, thank you.
It's here now, bro. Yeah, it's here now. I don't know if it works. I'm assuming it does, but before I didn't have the breakout room option. Yeah, that's what I'm used to. Okay, yeah. Sorry to put your legs to work. Sandy, are you listening?
Yes, Judge.
On diversified, I've got the gray folder. I'm assuming that means the complete file is off in the storage building.
Yes.
All right, so I'm anticipating another 3 minutes. If I haven't seen plaintiff's counsel, I'm going to set aside the default judgment and grant the motion that Ms. Jackson has filed. If we get an email address, can we email her the complaint so she can file an answer?
Yes, we can do that. I can get the file.
Okay. All right. Ms. Dawson Jackson, I'm going to unmute you or ask you to unmute yourself.
Okay.
Can you provide an email address?
Austin Juanita, AUSTIN JUANITA @hotmail.com.
Nice, easy one.
Mm-hmm.
All right. So in another couple of minutes, it's going to be 30 minutes since the case was scheduled. And at that point, I'm going to give you the automatic win, and I'm going to set aside the default judgment that was entered. And I'm going to ask you to file an answer to the underlying complaint. I got your email address because my civil department is going to email you the complaint that was filed back in 2015 that started this action. Understood?
Yes.
All right. So we're just waiting a couple more minutes so we can give plaintiff's counsel a full 30 minutes to appear.
Drop it off, or can you email it back? Do I email it back to you?
You could do that. You could email your answer, sure.
Okay,
So just give me a few more minutes to make it official.
certainly.
Mr. Nate, any success?
Unfortunately, no. I did find a different number, but still no answer. I left her a message, and I'll shoot her a quick email, but I don't know if she'll see that.
Thank you. Ms. Petway.
Yes, Your Honor.
Did you and Mr. Shropshire have enough time?
We did, Your Honor, and I'm happy to report that we have been able to reach a resolution.
Beautiful. Tell me.
Your Honor, I'm going to put on the record what our agreement is, but I don't know if Your Honor would prefer us to just submit it under the 7-day, or I can email it. I did get his email address just in case you wanted that. We could email it to him and then submit it to the court. So let me just put the terms first.
Sure, go ahead.
The parties agreed to a total sum of $500. Defendant will make $50 monthly payments beginning September the 15th and continuing on the 15th of each month thereafter.
Awesome. All right, so here's what I'm going to suggest. You prepare a consent judgment, email it to Mr. Shropshire. Mr. Shropshire, just respond to that email with a yes, I agree, or no, I don't. If it's a yes, I agree, counsel will submit it with 2 signatures on it. She'll sign your name. She'll submit it to the court. I'll sign it and make it real.
Sounds good.
Understood? All right. Any questions?
Not at this time.
All right. Good luck to you, sir. Counsel, have a great day.
Thank you, Your Honor. I'll be back at 10:45.
I'll be here.
See you then. All right. Bye
All
now.
right.
Thanks.
Bye-bye.
Bye.
Thanks. Bye.
All right, Miss Austin Jackson, you can unmute yourself.
Okay.
It is officially 9:15, 30 minutes after the case was called. So I will set aside the default judgment. And I'm going to require you to file an answer within 14 days.
Okay.
So as I said, my civil department's going to email you a copy of that complaint. That'll probably be today or tomorrow. And you'll have 14 days to get a response back to us. Understood?
Yeah, just a question now. They garnish my bank account. Do I get my money back?
We will also quash that garnishment.
So they can't come after me now?
Well, not until they see me again.
Okay.
Right? So we'll schedule a pre-trial. That'll be after the 14-day period. So you submit your answer to the court. That answer goes to Diversified Members Credit Union. Then we'll get together for a conversation and see where we're at.
Thank you.
And if you don't receive the email, who do you contact?
Do you have any questions, ma'am?
I think you answered all my questions, and I thank you so much for your time.
You're welcome. Enjoy your day.
You too. Bye.
Why don't you ask?
Good morning, Ms. Diskick.
Good morning.
What file are you calling in on?
I'm here for case 145444
No.
GC.
Give me some names.
Oh, I'm sorry.
Names work for me better than numbers.
National Collegiate, that, on behalf of the plaintiff. National Collegiate.
Thank you. And when is that one scheduled?
9:30.
All right, and I do not have anybody named Ivy in my waiting room yet, so hang out.
Okay, thanks.
Good morning, Mr. Levitt.
Good morning, Your Honor.
All right, what time were you scheduled?
9:30.
Okay. Don't see the other attorney yet, so just hang out with us.
Okay.
Heather, we haven't seen anybody from Kirkridge yet, have we?
No,
I'm here. Sorry.
No. I know you're here. That's why I'm trying to find the attorney for Kirkridge.
Oh no.
Good morning.
I just.
Is that you, Mr. Nichols?
Yes, Your Honor. I'm here for Kirkridge.
Awesome.
My lawyer.
All right. And
My lawyer
what's your
just said
lawyer's
I
name,
got
Ms. Kroll?
Ronald French.
Okay, I have not seen Mr. French yet. Have you talked to Mr. French recently?
Yeah, I talked to him this morning. He said he will be dialing in soon.
Okay. All right, so let's watch for him. Heather, one of our 845s was Michigan Schools Credit Union versus Donald.
Mm-hmm.
I'm gonna take that one off the docket because nobody showed up.
All right.
And Mr. Nate.
Yes, sir.
Still haven't seen Mr. Luciani.
I have not, and I haven't heard back from Jennifer
And
yet.
you haven't. Yeah, and you haven't heard from the attorney, so I'll keep hanging out if you want to. It's been over 30 minutes.
I mean, I'm not sure how long you'd like to wait. I do have a 10 o'clock.
I don't like to wait at all. I'm not a patient man, but I've got plenty of work this morning. So if you want to be nice, we'll wait a while. If you want to request a default judgment, you can submit one under the 7-day rule and give opposing counsel a chance to respond.
Yeah, as I say, why don't we do that? I'm not sure. We'll still try to get a hold of Jennifer, find out what's going on, but why don't we do a default under the 7-day? Because I don't know what's happening on this one either. As far as the defendant's position, we haven't really heard from. They're working with the debt settlement company, which hasn't really contacted our office in a couple months, which is a little atypical for them. But
right. Okay.
So,
submit under the 7-day rule. That'll give opposing counsel a chance to respond.
Perfect. All right, that sounds good to me. I'll get out of here. All right, thanks, Your Honor.
You're welcome.
Judge, Miss Palin just came in, and that's the one for with Nate Preston as the other attorney. I'm admitting her now.
Bring her in. Let me see if I can get him on the phone.
Okay.
Thanks for calling Stinger. Stinger, what can I help you?
Could I speak to Mr. Nate, please?
I don't know if he's in yet. Hold on one second. May I ask who's calling?
Yeah, I just had him on my Zoom meeting. This is Judge Oakley, 34th District Court.
Okay, thank you, sir. Hold on, let me see if I can get him. Hold on,
Yeah,
please.
if you can, ma'am, I just need him to get back into the Zoom because we were waiting for opposing counsel to show up and she showed up as soon as he signed off.
Oh, wow. Okay, hold on, sir.
Thanks.
Judge, I'm going to step away for 1 minute.
Yeah, go ahead, Heather. Mr. Levitt, if you want to give opposing counsel a phone call, see if we can get them online, we'll get some business taken care of.
I'll do that right away, Your Honor. Thank you.
Good luck.
Okay, so holding he's back on right now.
Thank you, ma'am. Enjoy your day. All right, good morning again, Mr. Nate.
Good morning.
And Ms. Pellion has joined us. So let's have appearances on JP Morgan versus Luciani.
Perfect. Preston Nate, P77884, appearing for JP Morgan.
Jennifer Palin, P80284, appearing for defendant. I appreciate the call, Preston. I did not have this notice of hearing, so I apologize for my tardiness, everyone.
No problem, counsel. So it's a pretrial. You two need a little breakout room, or what do you need?
Actually, just we've already been in contact and we hopefully are close to a settlement on this one. So I think if we just schedule everything 90 days out, we won't hopefully need any further court proceedings. I don't know, is that okay with you, Preston, as well?
Yeah, I mean, usually we do get these worked out. So yeah, I mean, if the court's amenable, that's fine with me.
I don't mind setting another pretrial. How far out? 90?
Yeah, I think, yes, I think that we'll have it all wrapped up well before then.
All right. That's fine. If there's anything I can do to facilitate that, let me know.
All right. Thank you. And I appreciate it again, your patience. Thank you.
All right. All right.
Have a productive day.
You too.
Thanks, Your Honor. Thanks, Jenny.
Mr. Beach, I'm watching the clock. 3 more minutes.
Okay, thank you, Judge.
Have you had any contact with the gentleman since our last court date?
No, I haven't.
Kind of makes me feel like an idiot for setting aside the default judgment in June.
Well, you know,
no comments necessary, Mr. Beach.
I'm trying to think of a diplomatic thing to say, but
And Mr. Levitt, did you have any luck? You're muted.
Yeah, Your Honor, I just left a message for Mr. Dressel on his voicemail. So I'm just waiting to see if he gets on.
Okay. Ms. Dixon, yours was set at 9 o'clock too, or 9:30?
9:30.
Okay, so you got a long wait. You don't happen to have phone numbers for your defendant, do you?
We do have a phone number, yes.
If you want to try it, go ahead. I don't have anything in the file.
Okay. Is it okay if I just mute and then give her a
Sure,
call?
absolutely.
Okay.
Absolutely.
Okay.
Yeah, thanks. Sir. All right, Mr. Beach, the clock just donged 9:30. Go ahead and submit your default judgment.
Thank you, Your Honor. We'll do so. Thanks. Have a good day.
Enjoy your day, sir. Mike, I'm going to guess you probably don't want to take a default judgment against counsel.
No, Judge, I can wait a little longer, but if not, we can
Okay.
adjourn it. I don't have a problem with it, so.
Your call. When you get tired of waiting, just wave your hand. Catch my eye.
Okay, thanks.
All right.
All right.
Your Honor, I just left a message for Miss Ivy.
Okay. Okay. Thank you.
Thank you.
Judge, I'm sorry, what case was Mr. Beach on?
Cash, CACH versus Quaw.
Oh, okay, thank you.
Oh, come on. Ronald French, please.
Me.
Mr. French, Brian Oakley from the 34th District Court waiting for you on Zoom. Kirkridge versus Kroll.
Yeah, I'm getting ready to log in. I had another one. What's the login number?
Hold on just a minute. 491-975-6074.
Okay, I'm logging on right now.
Thank you.
Good morning.
Good morning, gentlemen. Your appearance is on Kirkridge versus Kroll.
Hi, good morning, Your Honor. Matthew Nichols appearing on behalf of the plaintiff, Kirkridge Park Cooperative.
Good morning, Your Honor. I apologize. I was in another hearing trying to get out of it. Ron French appearing on behalf of Ms. Kroll.
All right, good morning, all. So where are we at with this one? In June, we thought the case was settled. Obviously not.
Yes, Your Honor. I could give a quick recap of the proceedings, Your Honor. And
Sure.
just for the record, the manager of the cooperative is running late. She does intend on joining in the Zoom hearing probably within just a few minutes. But Your Honor, this was a complaint to recover possession of the co-op dwelling unit based on material violations of the occupancy agreement, specifically that the defendant was storing and or cultivating marijuana in the unit, which was a violation of the cooperative's drug-free housing policy. We were before Your Honor on June 16th, as you recall, and we placed the terms of a settlement agreement on the record. That settlement agreement was memorialized in writing by the parties and signed by the defendant on June 19th. That agreement resulted in essentially the conditional dismissal of the case upon the defendant's agreement that she agreed to vacate the property and first remove the plants from her unit. The plants had to have been moved by June 25th, and the co-op was entitled to conduct a unit inspection by then. If the plants were removed, the defendant would have until July 18th to vacate the property. The plants were removed and inspection was conducted on the 25th, albeit there was a little bit testy of one, and the cooperative had to contact the local authorities for an escort to the unit because the defendant and or her boyfriend were following maintenance staff throughout the property and harassing them. But all that aside, the inspection occurred, the plants were removed, and at that point, the cooperative had also agreed that they would return 1/2 of her membership equity to her. That was done, which is I apologize, Your Honor. I was getting a phone call from the site manager.
No problem.
So with the return of her equity, it was agreed that she would get 1/2 upfront to assist with any costs of moving, and that the remaining half would be returned pursuant to the cooperative's bylaws and occupancy agreement. That's not very common of an instance to occur, whereas normal policy dictates that a member's equity in their co-op share is not returned until after they vacate the premises, after any repair or unit rehab is completed, and any outstanding amounts to the corporation are paid, and then a new member comes in. So the cooperative went out of its way to adjust this policy to assist the defendant in moving. She did get her check for 1/2 of the equity, which was $3,250. We're here because by July 18th, the defendant had not vacated the property. She is still in possession of the property. And we filed an affidavit of default based on the settlement agreement, which the parties agreed that if the defendant had not vacated timely, that would be the course of moving this court for a judgment of possession and a writ to issue. The defense had, I believe, an opportunity to respond to the affidavit of default. We have to date not received objections from the defense counsel or otherwise as to our affidavit of default, which was served on counsel on looks like July 21st by mail, and a copy of the affidavit of non-compliance was also emailed to counsel. So, Your Honor, based on the settlement agreement, it's a binding and enforceable contract between the parties. The defendant agreed to move by a certain date based on certain conditions that all the parties agreed to. That has not occurred. Because that has not occurred, plaintiff's position is, and we're here today asking the court for entry of a judgment of possession.
Thank you for the recap. Mr. French.
Your Honor, first of all, I was not retained on the second portion on the default. If Ms. Kroll wants to retain me, I will, and if the court will allow, I will respond. However, Your Honor, my client has cooperated all the way through this thing, give or take a little bit of pushing and shoving from both sides.
Well, let me stop you, Mr. Frank. Let me stop you. Either you are or you aren't representing her today. So if you want a breakout room with Ms. Kroll to decide that, that's fine. I don't have any problem with that at all. But I'm not going to let you talk to me unless she's agreed to let you represent her.
Okay, so we can just do that right here. Ms. Kroll, am I going to represent you on this second matter? Okay.
Okay,
So,
go ahead.
So just a quick response, Your Honor. Because of COVID, she could not find a place. She's applied to 10 or 12 places, and nobody will take her in because of this COVID thing. Now the mandate has moved even further out. And I'm not sure how the court can respond on that on the legal end because of the mandate being moved. She's looking for a place. She's actually
Let me stop you. Let me stop you. This might help you. I will sign an eviction order in a city minute when it's not about money.
Well, I got that, Your Honor. All we're asking for is some time. She's cooperated, and the COVID thing has put her behind the ball on this one. So all we need is a short period of time. I'm not sure where she's at with, she told me she may have had a place. I talked to her, just the other day. So we would just need a little bit more time and this will be done. We do have an agreement, but the COVID thing has not helped her through this because there's no places available. Everybody's being,
would it be of
stay there.
assistance to have? Would it be of assistance to have you two attorney types into a breakout room?
I would be willing to talk to Mr. Nichols if he would be willing to entertain that.
Your Honor, I don't think that's something that I have any authority to do. And in fact, I'm getting comments from our client, the cooperative, that we don't have authority to extend any more time to the defendant, mainly because her behavior has deteriorated at the cooperative. There's complaints from neighbors. And I'm waiting on the manager to come in. I don't think it's necessary for any testimony about this. The settlement says what the settlement says. If the court were to enter in a judgment of possession today, pursuant to it.
Let me stop you, Mr. Nichols. It looks like your manager might be in the waiting room. So let me bring her in. Sorry to interrupt, but I just wanted to bring your manager in.
No, don't worry, Your Honor. I appreciate it.
Looks like they're having trouble getting their audio connected.
Yeah. Well, Your Honor, as I was saying, under paragraph 5 of the settlement agreement, upon a default and entry of a judgment of possession, a writ of eviction would issue no sooner than 10 days. That 10-day period baked into the settlement agreement is the only authority that I have, which would extend Ms. Kroll an extra 10 days before a writ could issue.
All right, thank you. I'm signing a judgment for possession. Move out date will be the 23rd. Anything else, gentlemen?
Nothing further, Your Honor. Thank you.
Thank you.
Good luck. All right, and on National Collegiate versus Ivy, what's your pleasure, counsel?
Yes, Your Honor. So
it's been more than 30 minutes. No, you were scheduled at 9:30, weren't you?
Yes, Your Honor.
Yeah, then let's wait a little bit if you don't mind.
Yeah, sure.
Mr. Levitt, you still okay?
Yeah, Judge, I can wait till 10 too. And if the other counsel doesn't show, I'll just make a motion for default and submit an order.
Okay.
All right, thanks.
Mike, have you ever given some thought to all the money that's sitting on those shelves behind you that you don't use anymore? You're muted.
I don't know, Judge. Anybody taking donations?
You know, when I ascended to the bench, I tried real hard to find somebody, and that was 20 years ago, and nobody wanted those books. 20 years ago, nobody wanted them. The only people I understand that take those is once in a while decorators will take a few just to, you know, throw on a shelf in a restaurant or something.
Or a mansion.
But you know, when I opened my office, that was one of my single biggest monthly expenses was update that damn library.
I hear you. I mean, it's incredible how technology is advanced. I remember having to go to law libraries to do research.
Yep. Well, you know what I just did with some of my books from my old law office? I just drilled holes in all of them and made a stand to put my elevated monitor on. Because I stand in my desk. So I used those. I had a bunch of stuff just stacked up. So I just used some of those old books. So at least it looks legal. And it really broke my heart. I'm drilling holes in those books that I paid big money for.
Yeah. That was a huge.
It looks good on a Zoom meeting, though.
It
looks
does.
very official.
You are right. That was the biggest expense in running a law firm was the books.
Yep. And a major pain in the ass because when you got the updates, you had to put them all in the books. And you know, I was a little one man shop, so I didn't have a bunch of people to do all that stuff. Like, you know, you big guys have all the lowly law clerks and stuff.
Well, we only have 5 lawyers here, Judge, so we're not that big. But I remember having to do the updates myself. Yeah, that was a pain. So.
Yeah, technology certainly has caught up with us.
Yeah, I kind of missed the days when a client would send you something in the mail and you could take a week to do it and then get it back to them. And then the fax machine came and that made it quicker. And now with the emails, every client wants something done yesterday.
Yep. Automatic response. Yep.
Yeah.
Yeah, we're not slowing down, that's for sure.
No, for sure.
All right, I'm gonna leave you two in charge of my courtroom because I'm tired of standing here and acting busy. I'm gonna go get something else done. Heather's watching the meeting room, so if anybody pops in, we'll let you know.
All right, thank you.
I'm looking for Mariah. If anybody's at a Mariah sighting, let me know where she's at.
Mr. Levitt and Miss Dixit?
Yes.
I just spoke to the judge. He said if you guys both want to file something under the 7-day rule, he'll put it on the record when he gets back in, but it looks like he doesn't have anything again till like 10:30. So if you guys want to submit that.
Do you want that submitted like today or?
Sandy, hold on, now let me ask the civil department, I'm sorry.
Yep,
Okay.
you can submit it either by email or fax. You can submit that today.
Okay, that's fine. I'll get right on it and get it over to you. Thank you very much.
Thanks, have a great day, guys.
Oh, actually, just to clarify, we had this was the defendant's objection to our petition to set aside the payment arrangement. So would that just be an order basically denying her objection?
Sandy, can you help out on that one?
Yeah, give me a minute to find that.
Okay, thank you.
Yeah, I believe that would just be the motion to set aside payment order would be granted.
Okay. 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 And you said this has to be submitted today itself?
You don't have to submit it today. You can put it in the mail if you want.
Okay. Okay. Thank you.
All right, thanks, ladies.
Thank you.
Thanks, have a great day.
Thank you, you too.
Thank you, you too. Hi, Miss Turner.
Hi.
Hi, I just want to let you know
Hello.
that, hi, your hearing's not until 10:30. I'm sure you're aware of that, but the other parties are not here yet. So I'm going to put you back in the waiting room until they get here. I just wanted to let you know that I do see that you're here, okay?
Okay, thank you.
Thank you. Hi, Chris Tyapel.
Yes,
What are you here on, please?
I'm sorry, what was that?
What case are you here on?
Oh, 210214.
What's the name of it, though?
The name.
They had a consent judgment that was entered.
Okay.
Midland Credit Management LLC versus Christopher Typely. Is that the name?
Yes, that's it. There was a consent judgment entered. So you are all set for today.
Oh, okay. Thank you.
Thank you.
Thank-
Thanks, Sandy.
You're welcome.
Good morning, Miss Petway.
Hi again. How are you?
Hello, I'm fine. Who are you here for this afternoon? I mean, this last hour.
Yeah, my timing was off too because when I left the last time, I could have sworn my next hearing was 10:45. I'm glad I followed up to check because it's actually 10:30, but arrived 15 minutes early. So I am here again on behalf of Midland. The defendant on this one is Latia Sampson.
Yep. All right. I see her in the waiting room, but we are good. We are going to wait for the judge. He'll be just a few minutes. Okay.
Okay. And I think I'm going to need to speak with her because she says she wants to try to resolve it. So
I can put you guys in. Do you want me to put you in a breakout room now?
That would be great. Yes. If you could go ahead and put us in a breakout room.
I'm going to bring her in, but there's also somebody, Will Sampson. So I don't know if he is on it also.
Oh, okay.
Hi, Latia. You're muted.
Sorry.
Yeah,
Okay.
that's fine. So can I get rid of your other phone?
You can.
Okay. I'm going to remove it. Don't touch anything. I'll take care of that. Okay.
Okay.
Miss Petway says that you guys are going to discuss some information. So I'm going to put you in a breakout room.
Perfect.
Okay.
Thanks.
You're welcome. Ms. Petway, were you all set in the breakout room?
Yes, we were able to reach a resolution. She was unsure. She couldn't find the button. I was trying to explain to her how to leave the breakout room. So can you bring her back?
I sure, yep, I just put to close her breakout room.
Okay, perfect. Thank you.
All right, so the judge will be out in just a few minutes, okay?
Okay, sounds good. Thanks.
Thank you.
Ms. Sampson, we're just waiting on the judge to take the bench. She said the judge should be back out in a few minutes.
Okay, no worries. Thank you.
Mhm.
Good morning, ladies. Counsel, your appearance for Midland versus Sampson.
Yes, good morning again, Your Honor. For the record, Stephanie Petway, P64543, appearing on behalf of the plaintiff.
Good morning, Ms. Sampson.
Good morning. How are you?
Wonderful.
That's good.
Ms. Petway, what do we have?
Your Honor, I'm happy to report we have been able to reach a resolution in this matter. The parties agreed
Awesome.
that the defendant will pay $100 per month, beginning September the 15th, continuing on the 15th of each month thereafter. I did obtain Ms. Sampson's email address so that I can email her that consent, and I explained to her that she can confirm that she agrees with the terms, and if so, I will sign for both parties and submit it to the court.
Awesome. Ms. Sampson, you understand that?
Yes, I do.
Do you have any questions, ma'am?
No, I do not.
Awesome. Good luck to you.
Thank you so much.
Thank you, Your Honor. Have a great day. Take care, Ms.
Ms.
Sampson.
Petway,
You too.
thanks for spending the morning with me.
Thank you, Judge. Bye now.
Bye-bye.
Judge Cynthia Howard is for West Village, or against West Village Estates, but they're not in yet.
And yeah, let's wait a minute and I'll try to call them.
Yep, and Anastasia Turner is for Beaumont. She was in earlier. I just told her that she was a little early though.
Okay.
I'm gonna bring Mr. Cox in. I don't know which case he's on, but it is an
Sure.
attorney.
He's probably on West Village. Good morning, Mr. Cox. Which file?
Morning,
are you on?
Judge.
Which file are you on?
I'm on your dreaded no progress docket for Frankenmuth versus Ostravanu.
Yeah, and I don't even have that file. Sandy, can you shed any light?
We settled it 3 weeks ago, and your
Do you
Honor,
have the
just
case number, Mr. Cox?
I do. It's 200740 GC.
Yeah, we received a dismissal yesterday on that.
Oh, did you? Okay. I guess, well,
So you're all
I should
set.
probably I should give them a call. They didn't get my check yet. So let me thank you, Judge. Have a good afternoon. Good morning.
Have a great day.
Thanks.
Do you want me to bring in Mr. Burke? Oh, you got him.
I just clicked him.
Okay.
Mr. Burke, which file are you on?
Your Honor, I have Beaumont Health versus Turner, although I think we're close to resolving it and it may not be on your docket anymore.
Yep, Ms.
It
Turner's in the
is,
waiting
and
room.
we've got Miss Turner.
Oh, great. I think, just to repeat what I said, I think we'll probably resolve it if you'd allow us in
Okay.
the breakout.
Let's get her connected and we'll put you in a breakout.
Thank you.
She's connected. So, Mr. Burke, you want to be put in a breakout room with Ms. Turner?
Yes, please.
All right.
Good morning, Mr. Green.
Good morning. 34th District Court calling for whichever attorney is going to represent West Village versus Howard today.
You know what? I'm not sure what I want.
Thanks. Counsel, did you have enough time?
Yes, we did.
Voicemail won't do me much good. I need her on Zoom.
Unfortunately, like I said, I'm not equipped to answer that. I don't have access to the file. Or obviously the chicken phone, there's all our phone calls.
And she's not taking calls.
But she stepped away from her office.
All right.
She's here in the office.
Okay, well, I'm not leaving a voicemail. All right, counsel, where we at?
Your Honor, we have resolved this case. Miss Turner,
wonderful.
I don't know if you can see, Miss Turner is at work and she said her break is at 11:20. And if I was to call her then, she'd make her payment. If she does, then I'll dismiss the case. I didn't ask her how she wants me to contact her though.
All right. Ms. Turner, real quick, give us your phone number and then I'm gonna let you out of the meeting.
586-224-3538.
224-3538?
Yes.
All right. Have a great day.
Thank you. Bye.
Counsel, let's do this. Let's put it on the no progress docket 30 days out with the idea either you're going to dismiss it or you're going to file something to get it back going, back on the calendar.
That sounds great, Your Honor. Thank you.
Have a great day.
Have a great day.
It looks like West Village got the message. I'm gonna bring them in.
Somebody did, yeah. Not the attorney, though.
Oh, true. Oh, that's right. I'm sorry.
It's all right. Good morning, Miss Samples.
Good morning.
It looks like we have at least one Howard in the waiting room. We're just waiting for your attorney.
All righty. Thank you.
If you know who that is, you might give him a phone call. We'll get you out of here early.
Sure, I can do that.
Thanks.
No problem.
Good morning, Ms. Howard.
Good morning.
And do you have Frank Howard with you?
He's sitting right next to me.
Good morning, Mr. Howard. We've got the manager online. She's trying to get a hold of their attorney right now. See if we can get started a little early.
Okay, thank you, Your Honor.
You're welcome.
Judge, it looks like they're in the waiting room.
Awesome.
I'm gonna step away for a minute.
Yep.
Judge, the attorney may be on another Zoom meeting, they're saying.
Okay, I've got Mr. Lamb, and I'm trying to bring him in, but his audio is not connecting, so that might be what's going on.
Okay.
All right, Judge.
Thank you. Trying to get Mr. Landman connected.
Oh, okay.
Mr. Landman, your appearance for West Village, please.
Good morning, Your Honor. For the record, Daniel Landman appearing on behalf of West Village.
Thank you. We've got Ms. Samples from West Village, and we've got Mr. and Mrs. Howard. Counsel, where are we at with this file?
Your Honor, this was a case that was stayed due to SIRA. My client has not paid in full. The current balance is $584.86. There's costs owed of $190 for a total of $783.86. I would note for the record that the tenants have signed a CDC declaration that was submitted in April.
So has West Village received any ceremonies, but not all, or received none? I'm not sure where we're at.
That I would have to yield to Ms. Temple for the answer.
This is Lindy. Renee is not available at the moment. Yes, we did receive monies from Sierra. It wasn't enough that it covered it in full.
All right, so the balance currently is $783.36, correct? Did I get that number right?
Including costs, Your Honor, that's correct.
Thank you. All right, Mr. and Mrs. Howard? You're muted, ma'am.
Yes, Your Honor.
There you go. All right, do you agree that you owe some, all, or none of the $783.86?
I believe I owe some.
$783.
I got a 7-day, we got a 7-day notice in yesterday's mail, but that was for this month. It wasn't for the past due. The 7-day notice just said that we owed this month's rent. It didn't say the back rent. That's the confusing part of this.
All right,
And
Mr.
it said-
Lamb, the 783 number,
Yes, Your Honor.
783 number, did that have anything about August rent?
It should have included August rent, Your Honor.
Yes.
Yes.
All right, ma'am,
And,
what did your notice that you received yesterday? What, there should have been a dollar amount on that notice. What was that?
$756.10.
All right, so we're some $30 off on the two numbers. Is that what you're telling me?
Yes, Your Honor.
Okay. It looks like Ms. Samples just went to go grab something, so maybe we can figure out that discrepancy.
Her 7-day notice was for $753.86.
All right, and that 753 is part of the 783 that Mr. Landman gave me?
Yes.
All right, so what's the $30 difference, if you can tell me, Ms. Samples?
Let me see. Well, when you pay by money order or check here at the office, there is a $10 surcharge. So those two money orders for the payments made incurred $20, and then I'm assuming the other 10 is court fees from today.
Your Honor, the other one is a $75 cash fee versus 65.
All right, Mr. Landman, I'm having trouble understanding your audio.
I apologize, Your Honor. The other $10 is that it's a $75 attorney fee rather than 65.
Okay, that didn't make sense to me. The $10 discrepancy is a $75 fee?
At the first, Your Honor, if it had been resolved at the first hearing, we would have only charged $65 as an attorney fee. However, it's now 75.
Oh, I got you. I got you. The 65 was already included.
Correct.
Okay. All right. So, Mr. and Mrs. Howard, do you agree that you owe the 753 amount?
Yes, I do. That's this month's rent. And I
All
didn't know
right, but you're just,
what I'm discrediting was I was told that I had to pay that amount in a money order or a certified check. I didn't have any other way to pay it. Otherwise, I wouldn't have incurred that $30 fee.
all right, so you're disputing the $30 portion of the 783.
Yeah.
Okay. Mr. Landman, breakout room would be of assistance?
Yes, Your Honor.
Okay. Would you like everybody in the breakout room?
Yes, please.
Heather, all four of them in a breakout room, please. I'll talk to Mr. De Silva.
All right.
Good morning, Mr. De Silva.
Good morning.
Just wanted to let you know that I saw you in the waiting room and we're waiting to see if Colomb is going to join us.
Okay.
All right.
Thank you.
Courtroom. Emily is in the building, but she's not in the courtroom. Okay. Hold on just a minute.
I can come in and transfer, Judge.
Yeah, I think I can do it. I just got to figure out where I'm going.
Yep, up at the top it says transfer. And then just hit 228 is Emily.
228?
Yes.
Thank you.
Yep.
Hello,
Annette Cologne, please.
this is her.
This is the 34th District Court call, and we're ready for our Zoom meeting with Mr. De Silva.
Oh, okay, I'm sorry, I didn't know it was right now. Is there, do you know, is there like a Zoom number or something? I think I remember last time I had to put in a certain number.
There is, you have a pencil?
Yes, right now. Okay,
491 975 6074.
the last four was 604.
6074.
Okay.
Thank you.
August, pandemic debrief that we need to do.
Oh, yeah.
Ben Ruby from the 19th is putting together a mass debriefing between courts.
Okay.
So I said, yeah, we want to hop in on that
Okay.
August 25th. I'll check with Heather to make sure there's nothing else on your calendar.
I got all exams.
I know, at 2 p.m. is when we're looking to do it.
I got a live exam at 1, 1:30, 2, 2:30, 3, 3:30.
Okay, all right. Are you okay if we still join and, or do you want us
Is
to
there a
hold our
requirement that
own?
I have to be there?
No, it suggests. Chief Judge and judges. So I could ask Judge Martin and Judge Green.
Invite them and let them know that I'm probably not gonna make it because it's Zooms, but we want to take the advantage because somebody else is doing all the work to set it up.
Absolutely.
Yeah.
And then for invitees, do you add anyone
I
you would like to
didn't
be?
look at the list. I didn't look at the list to see who they were.
Attorneys, defense, and prosecution, any of our court stakeholders. So I thought maybe we invite one or two of the.
I didn't invite the MIDC, I invite local prosecutors, and I'd also send it out to, maybe all the PD. That'll satisfy the requirement. Yeah, okay, great, thank you. All right, back on the record with West Village versus Howard.
Yes.
Mr. Landman, where are we at?
Your Honor, I think we've got this figured out. I believe that the Howards will agree to the entry of a judgment in the amount of $574.86 plus costs of $199 for a total of $773.86. That's $10 less than the figure that I gave you previously.
Agreed, Mr. and Mrs. Howard?
Yes, Your Honor.
All right, go ahead, counsel.
Your Honor, the Howards would have 10 days to pay. However, if the CDC moratorium remains in effect, then obviously that length of time would be lengthened because the Howards have submitted the CDC.
All right, and are we going to do that via email? How are we going to do the consent judgment?
Your Honor, I can, the Howards give me permission to sign their names. I will do so, and I will email the judgment to the court.
Mr. and Mrs. Howard, agreed?
Agreed.
All right, any questions, folks?
No, Your Honor.
All right, good luck to you.
Thank you.
Your Honor.
Thank you, counsel. Thank you, Ms. Samples.
Thank you.
Good morning, Mr. De Silva. Good morning, Ms. Cologne.
Hello, good morning.
All right, so we met back in June 16th, I believe my note says. At that point, there was a Sarah application in the works. So where are we at, Mr. De Silva? Has that come through? You're muted, sir. You're muted, Mr. De Silva.
Can you hear me now?
I can, thank
Okay.
you. Where are we at with Sarah?
I have not received anything, no letter, no, I don't know who to contact. I've tried everything in my side. I don't have anything.
All right, ma'am?
Yes, I haven't heard anything either, but I have called probably about 3 times in the last, since we were in court last. When I call, they just say that, you know, they got bombarded with applications after it was on the news, and that as soon as a worker was assigned to my case, that they would be getting in touch with me. And I actually have a friend that did it about a month before me, and she heard back about 2 weeks ago, maybe at the most, but about 1.5 weeks ago. So I'm hoping to hear something really soon.
All right, and have you made any payments?
No, but I do have my rent payment right now for the month of August. Haven't been able to transfer it, and I was going to get a money order and ask my sister to put it at the Chase Bank around the corner for me into um Marcel's account tomorrow when she takes me to the doctor, because I don't have any other way to do it right now.
All right, Mr. De Silva, what's your pleasure?
I mean, I'm trying to work with her, but she said she was gonna pay last month too, and with her sister and help out, and I didn't receive anything. And she said August 1st she'll pay and haven't received anything. I mean, I just don't know what else I can do. I mean, it's been 4 months, and last month now she ignored me. She won't even take my phone call. She won't even answer my email or my text or nothing. So she said
Well,
last month she would pay as soon as possible, and I haven't received anything.
Well,
All
I
right,
wasn't able
give
to
me just
take
a minute.
your
Hold
phone
on,
call.
ma'am. Hold on, ma'am. Hold on. Just give me just a minute and I'll be right back.
Okay.
All right, folks, if you can unmute yourselves. Mr.
Hello?
De Silva.
Yes.
Mr. De Silva, what is the total amount due as of right now, inclusive of court costs and everything else?
The 4,020 plus the court cost. So that
All right, so the 4,000, let's do it this way. 4,020 is made up of what? What's the breakdown on that?
That's $220 for April. And then $950 for May, June, July, and August.
$950 each.
Yes.
And then your court costs, I'm looking to see if I've got a receipt in the file.
I think it's the 55 plus the bailiff. 55 for the
55 was your filing fee, and I don't have a record of what you paid to serve.
I got it right here. I just sent it out. It's,
34.
34, yeah.
All right, so the 4,020, I'm doing the math, plus 55, plus 34, $4,109. Do you agree with my math, Mr. De Silva?
That is correct, Your Honor.
All right. Ms. Cologne, do you agree that you owe some, all, or none of that $4,109?
Well, I do have a question about 950.
Well, let's do it this way.
Yeah.
Why don't you answer my question, and then we'll move on to your question.
Some.
All right, what amount of that 4,109 do you agree that you owe?
It would be $875 plus $50 late fee, which equals $925, not $950.
No, it's $75 late fee, not 50.
It was 50 before, and it was 50 last time you came to court.
No.
What's your lease say, ma'am?
$875 per month, and then
No, I mean, what's your late fee in your lease? What's it say about a late fee?
I'm not sure. I would actually have to go back and look because I never had to pay a late fee before, because up until May or June, I've never been late. Or I'm sorry, but I think the first month was April. Yeah, April, May.
All right, well, here's what paragraph 3 says in the lease that was submitted by Mr. De Silva when he filed. In the event that the rent is not paid by the 5th day of the month, the tenant agrees to pay a late charge in the amount of $25 plus $25 for each additional day such rent shall remain unpaid.
But I stop at 75, Your Honor. So it doesn't it doesn't accrue so much. That's why.
Right.
Yeah,
right.
I stop to help the tenants out. Yeah.
All right, so would you agree with me, ma'am, that Mr. De Silva, pursuant to your lease agreement, can charge you a $75 late fee?
Yes.
All right, so you agree that it's $950 for each of the months, May, June, July, and August, yes or no?
Yes.
All right, do you agree that you owed a balance of $220 for April?
I owed a balance of $145.
Plus 75, Your Honor. That's $220.
Would you agree that it'd be a late fee for April if you didn't pay the month's rent within 4 days?
Well, the 145 wasn't for the month of April. The 145 was from months earlier, from before that, when something happened.
The 145, Your Honor, was for February rent, but she was going to pay it in April. That's why it's on April's statement that it was never paid.
So yeah, I just didn't know it had a late fee attached to it.
Okay.
But yeah.
That's
Okay.
fine. But no, I agree to that though. That's fine.
Okay. All right. And do you agree to the $55 filing fee and $34 service fee for court costs.
Well, I'm still waiting on the Sierra to,
But that doesn't answer my question, ma'am. What I'm asking you now is, of the $4,109 that Mr. De Silva is seeking, do you have any argument that any of that money is not due him?
if I'm responsible for the court filing, excuse me, if I'm responsible for the court filing costs, then yeah, I'm responsible for them.
Okay.
But I wanted to add that I wasn't not taking his calls or text messages. I didn't have my phone. I was in the hospital and woke up in the ICU after being unconscious for 6 days. My phone was with my property where my battery eventually died, and I didn't charge my phone and get to use it until the day I came home from my sister's house from the hospital. I went to my sister's first, then home, and he was the first person that I text. I didn't call because mentally and physically I was exhausted. I was sick. I'm at very high risk of getting my leg amputated above the knee. I was in the hospital because I was sepsis, and I had to be on antibiotic IV to try to clear that up because I had a plate and screws removed from my leg in hopes that the infection would go away. But it's set in the bone, it's settled in the bone. And so I'm dealing with that. And on top of that, I also have to get spine surgery of my cervical and thoracic spine. And so I'm dealing with that, which I can't get done because I still have infection in my body, and I've lost use of my right hand, and just I have a lot going on, and I've done my best to apply for what I could. And like I said, I'm just waiting on the Sierra decision in hopes that they'll help me with the rent that I owe, and also a couple months rent in advance, just to give me a little bit of of a break on that, because I'll probably be in the hospital for a little bit, and then maybe at my sister's or at a place like Regency or something like that for a month before I come back home.
All right. Ma'am, I am not unsympathetic about your health issues, but I also don't think it's fair that Mr. De Silva has to wait forever to get his money. He's now 4 months plus behind on the rent. You've had 7 weeks since our last conversation, and from your conversation, or from what you told me, you've made 3 phone calls. I don't think that's using best efforts to tap into the ceremony, and I also think that you should have made some payment to him in the meantime. So I will enter a judgment in the amount of $4,109. If you can work out some kind of partial payments with Mr. De Silva, that's fine. Otherwise, he is entitled to a writ of eviction after August 23, 2021. Mr. De Silva, I'll leave it to you to submit that judgment, or contact my civil department about how you can submit that judgment for my signature.
Thank you.
Ma'am, do you have any questions?
Did you say that the eviction would be started or could be started on the 23rd?
On August 23rd, he can seek a writ of eviction, and then it's just depending on how soon he can get the court officer scheduled to actually do a physical eviction. Legally, he's entitled to the eviction on the 23rd after that document is signed. Practically, it usually takes some time after that to schedule.
Well, I'm just hoping to get this here a decision before then, so we can, square
I
this
hope
up.
so too, and I'm sure Mr. De Silva would rather have his money than evict you.
I
Good
hope
luck.
so. I mean, I've been here
Mr. De
almost 6
Silva,
years.
Mr. De Silva, do you have any questions?
No, Your Honor.
Good luck, folks.
Thank you.
Thank you.
Judge, is that the end?
Yeah,
You want me to
you
close
want me
it?
to shut down?
Yep.
Yeah,
Yep,
you
I
shut
will.
down Zoom, I'll shut